Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. In this presentation, we would look at the EU sanctions framework, and more specifically, we would look into the following points of this framework: key elements, key legislative provisions on which the EU sanction framework is based, the decision-making process involved in the adoption of the EU sanctions, territorial and personal scope of a typical EU sanctions regime. We would briefly touch upon current regimes in place, and then finally we would conclude by discussing the competence of the EU institutions and member states in the implementation of the EU sanctions. The EU sanctions are implemented pursuant to the powers granted to the EU institutions within the framework of common foreign and security policy, which is defined in Articles 24 and 29, in particular, of the Treaty on European Union in very broad terms. And it's recognized that those terms are sufficient to allow the European Union to adopt international economic sanctions. In effect, most, if not all, of the EU sanctions regimes are adopted under the powers granted to the Council in Article 29 of the Treaty on the European Union. Once the principal decision is made under this provision with respect to the implementation of a sanctions regime, then the implemented measures are taken either at the level of the European Union or at the level of the member states. And if the relevant measures are taken at the level of the European Union, then the relevant powers will be granted under Article 115, this time of the Treaty on the Functioning of the European Union. So what we have in effect is a double-tier system of implementing EU sanctions, where the first tier is the taking of a political decision by the Council at the level of where the decision is made unanimously by all member states, and the powers are granted by the Treaty on the European Union. And then once that political decision is taken unanimously, then the implementation of measures are taken either at the level of the European Union, whether the relevant measures would typically done by a qualified majority, or at the level of the member states, depending on whether that implemented measure falls within the competence of the European Union or a member state. And the procedure would be similar, whether the relevant decisions are made to implement the sanctions regimes of the United Nations, or whether they're made to implement autonomous EU sanctions regimes. In principle, the European Union is committed to give efficient and prompt implementation to any sanctions taken by the United Nations within 30 days period, and a shorter period if the relevant measures relate to terrorism. Now we would quickly discuss the territorial and personal scope of the EU sanctions, which is similar regardless of whether relevant regimes relate to the implementation of UN sanctions or the autonomous sanctions of the European Union. I've taken Article 10 of the relevant regulation implementing sanctions in connection with the situation in Burma, but the relevant provisions would be identical in any EU sanctions regime. In effect, it's the standard language which is used coherently, regardless of whether the relevant sanctions are EU implementing sanctions or EU sanctions implemented the UN sanctions regime. So the standard language is produced at this slide, and in principle, the territorial scope of the EU sanctions requires that there is either a territorial connection to the European Union, in which case any person, whether individual or corporation, whether national of the European Union or not, whether resident in the European Union or not, shall comply with the EU sanctions. So to the extent your activities come within the territory of the European Union, you have to be aware and you have to follow the European sanctions. And this may seem intuitive, but it may not seem that obvious with respect to specific actions. For example, with respect to payments, any payment in euros will, at one moment of time, will be cleared through the European banking system. And arguably, even if the payment made between two parties outside of the European Union, to the extent it is processed in euros, it has to comply with the European sanctions on the basis that it will come within the territory of the European Union. The second element of the jurisdiction is the personal scope of the jurisdiction, where any EU national or any EU company has to comply with the EU sanctions worldwide. So regardless of whether the activities are within the territory of the European Union, as we've just discussed with respect to non-EU persons, or outside of the European Union, they have to comply with the EU sanctions in any part of the world. Meaning that we have the third category of persons or activities which do not touch the territory of the European Union, either by way of territorial connection or by way of personal connection. So to the extent we relate to these type of activities, they are outside of the scope of the EU sanctions and in principle do not have to take the EU sanctions into account. Similar to other sanctions regime, we generally briefly discuss the possible classification of the EU sanctions just to get a better idea what are those regimes about. And here, the first way of looking at the EU sanctions is to see whether those are implementing the UN Security Council resolutions imposing the relevant regimes at the UN level, or we talk about autonomous EU sanctions, which are introduced by the European Union independently of any wider political agreement at the level of the United Nations. It has to be said that most of the sanctions today in the European Union are actually implementing the relevant sanctions regimes introduced by the United Nations. The most noteworthy exceptions where the European Union introduced its autonomous sanctions are the current regimes introduced against Russia and Belarus. Having said this, even with respect to the UN sanctions regime, it would be incorrect to consider that the UN just replicates the relevant regimes. It certainly implements the regime as such, but then it can add additional persons to the lists. Some additional restrictions can be added. So in most of the cases, even when we talk about the UN sanctions regimes, it's important to identify the relevant EU regulation implementing that regime and look precisely at the letter of that specific regulation. Another way of looking at the European Union sanctions is to contrast the sanctions which aim to change the behavior of specific states and are aimed at the states versus the sanctions which are addressing a specific issue, like the issue of non-proliferation or fight against terrorism, and which in principle are not linked to the activity of the specific states. Final way of looking at the EU sanctions is to distinguish between embargo type of sanctions, which would prohibit any kind of economic relationship with specific states or specific regions within those states, and the targeted sanctions, which are more individual based and are aimed either at restricting all types of transactions with specific individuals, where we talk about so-called individual asset freezes and prohibition to provide economic resources and funds to those individuals, typically coupled with travel bans when the relevant individuals will be prohibited from entering the territory of the European Union, or the targeted sanctions which aim to restrict specific trade or finance relationships with the sanctioned countries or group of persons living in those countries. Whilst we can find the examples of both of those sanctions in the current sanctions regimes of the European Union, obviously the general trend is that targeted sanctions are preferred as they are believed to better serve the political objectives without imposing unnecessary humanitarian suffering for those parts of the society who, in the opinion of the European Union, are not directly involved in the relevant behavior of the states which the European Union wants to address. On this sanctions map, taken from the website of the European Union, we can see the current EU sanctions regimes. Largely, as we can see from the map, those relate to the situation in the Middle East, where almost every country in one way or another is subject to certain restrictions. Another example of sanctions regime is Africa, where again they apply to many states there. Outside of these two regions, Russia and Belarus, together with Myanmar, Venezuela, would be the examples of the sanctions regimes of the European Union, which are currently in place. An important point which describes the EU sanctions is the competency of the EU decision-making bodies and EU member states. As we discussed, the regime starts with the decision within the framework of the common foreign and security policy, which is made by Council. But once that decision is made, which is by itself binding on the member states and does not create rights and obligations for the individuals, the decision has to be implemented. And here, the implementation is made either by the European Union, to the extent that relates to the competence of the European Union under the treaties, or by the member states, to the extent that relates to the competence of the member states under the treaties. Most of the sanctions would relate to trade or finance relationships with third countries, and accordingly would fall within the competence of the European Union. So most of the implemented measures are also taken at the level of the European Union, in accordance with the procedure set out in Article 215 of the Treaty on the Functioning of the European Union. The most noteworthy examples where the member states retain their competence would be the introduction of arms embargo, which, although would equally relate to the trade relationship with other states, but remains within the competence of the member states, as well as the enforcement of the travel bans, where the exact enforcement and the exact measures leading to that enforcement is to be taken by the member states. Another area where the member states retain their competency is the actual introduction of penalties, as well as the enforcement of the sanctions, both taken by the European Union and by the member states themselves, where the role of the European Union institutions is limited to the general, to certain minimum criteria for the relevant offenses or the penalties for those offenses, as well as the minimum, for example, exemptions which may be acceptable in the view of the obligation of the member states to ensure that the penalties are dissuasive, effective, and proportionate. So thank you very much for watching. I hope you enjoyed the video and hope to see you at the next presentation.